Attorney's time window.
I close the account.
Hands up!
16-year-old James Johnson appeared in court today for sentencing in a case tied to a stolen Kia investigation from December 2024. Police say Cleveland officers were investigating a string of car thefts in the Midtown neighborhood when they spotted a stolen Kia near an abandoned home. Johnson, who was 14 at the time, was allegedly inside the vehicle with 2 other juveniles. Hours later, officers returned and found Johnson asleep in the stolen Kia. Bodycam footage shows police giving commands before prosecutors say Johnson tried to ram a police cruiser while attempting to escape. An officer then fired 1 shot, hitting him in the shoulder. Johnson later pleaded guilty to 5 charges, including felony assault on officers, failure to comply, and receiving stolen property. Police also recovered a firearm from the vehicle. Because he was charged as an adult, the case and sentencing proceedings are public.
We are on the record in cases 704-399 and 704-398, State versus James Johnson. Mr. Johnson is in the courtroom with his attorney, Mr. Petropoulos, and on behalf of the state of Ohio is Ms. Terlatti. We are here for sentencing. The sentencing materials that I have are the PSI, some victim impact statements. I received and shared with counsel 3 letters that were dropped off with the court from the defendant's family members, sentencing memorandum from the defendant, and sentencing memorandum from the state. There was a request for the Indian Wells records from the juvenile ODYS. We had requested them and we were not able to get them. However, a good amount of information was provided in defense's sentencing memorandum with records from Indian Wells. It's not a requirement of sentencing that I have his institutional records. The information that I have, I believe, gives a general overview of what you intended to be able to present, and so I'm satisfied that I have all the requisite information as it relates to that. Or did I say Indian River? Is there anything that I'm missing?
No.
Okay. And just looking at the PSI, I'm not exactly clear on what specifically the victims are requesting as far as restitution. Do you have a number and a basis for those?
Yes, Your Honor, I do have a number. I will say the state had attempted to get like more formal receipts, and those were not provided by either of the victims. And both of them have been notified of the date today, but neither of them were able to attend the sentencing. So, Your Honor, I can say the amount they are requesting, but I don't have kind of the formal receipts to back that up.
Okay. But you had informed them that that's necessary for restitution?
Yes, Your Honor.
Okay. All other victims have been notified?
Yes, Your Honor.
Okay. Then I'll allow the state to present, if you could, because there was a lot of different instances between these 2 cases. I believe like on one day there was multiple instances and different victims. So if you can, when you do present, as it relates to, for example, count 1, the felonious assault, and then count 2, that was amended to the, without the firearm specifications, if you could delineate the conduct between the counts.
Okay.
All right, go ahead.
Thank you, Your Honor. Just kind of to start, I understand this court has a PSI, but I would just like to kind of give a little bit of an outline of the 2 cases, and there is also video available from both of these cases. I would like to begin just kind of time-wise linearly with case 704399. I'm so sorry, 704398. This is the aggravated robbery case. The victim in this case is a minor with the initials PD, and he was essentially walking down the street. There is RTCC footage, which I will show in just a moment. He is walking down the street when a vehicle comes directly at him, and he has to jump out of the way. After jumping out of the way, the defendant exits the driver's seat and is pointing a gun at him. They kind of go across the street, and the defendant essentially robs him of the shoes on his feet. There was other individuals present in the car, but he recognized the defendant as the driver and the person that pointed the gun at him, and he did know him from around the community. And when this incident happened, the defendant was driving a gray Hyundai Tucson, which was stolen from John Souza, which is spelled D-S-O-U-Z-A. So, Your Honor, I do have RTCC footage of this incident. This is October 10th of 2024 at the corner of East 146 and Sinclair. I am going to start it at about 10 seconds. Mr. Wells, it should come up on your screen as well.
Oh, well, okay, I'm sorry.
Is it mirrored?
I don't see anything.
Is it on? The monitor is on?
There's an orange light on it. It was on. It's on here.
Is it working?
It says monitor status inactive.
Mark, you can come around. Your Honor, I'm going to direct you to kind of the upper middle toward the left of the screen. There is a figure very close to the top of the screen that you will see walking. And then across the way, there is a vehicle that you will see driving over, and that's the incident that we're referencing. What time of day is this? Your Honor, this was at 3:54 in the afternoon, and it is broad daylight, and there are multiple other vehicles around.
I've seen it.
Your Honor, I'm pausing at 44 seconds. I believe, hopefully you just saw the victim in this case, again a minor, PD, was walking. He physically had to jump out of the way of the vehicle that defendant was driving. The defendant drove onto the sidewalk. And then when the victim jumped out of the way, he began crossing the street. There are numerous other cars driving by. And from the victim's testimony, but I believe also the video, you can see that defendant exits the vehicle holding his arms straight out with what appears to be a firearm in his hand. And the victim does testify as they kind of move somewhat off of the screen that the defendant forced him to the ground and took the shoes off of his feet. And as stated, he was able to identify the defendant by name. He was also able to provide officers with the defendant's Instagram in order to provide more of an identity. Your Honor, the next case being 704-399. This is about...
I'm sorry,
yes.
so both counts in count 1 and count 7, those both have firearm specifications?
Your Honor, no, I believe only count 1 kept the firearm specification, and I believe in count 7 the firearm specification was nullified.
That needs to be amended to be decided.
Okay. And continuing to incident number 2, case 704-399. This incident happened about 2 months later on December 14th of 2024. As kind of some background on this case, there had been a string of car thefts happening in the area. Officers were aware that a vehicle had been stolen, and officers were patrolling the area, and they saw that vehicle parked at an abandoned home. When officers arrived, they did block that vehicle in at the home, and they saw the defendant as the sole occupant in the front seat, in the driver's seat, and he was asleep. Your Honor, just briefly, I want to show the photo of the address where that occurred. This is just from Google Maps, but I just want to represent how thin this driveway is. I will be showing footage of what occurred, but it's a little bit harder to tell space-wise. But this is the driveway that the stolen vehicle was backed into. When officers arrive, they kind of circle the vehicle. They are attempting to wake up the defendant, and he is not waking up. They are able to see that this was a stolen vehicle. It's a Kia Sportage that was stolen from Nicole Vendrey. It's Vendrei. They also learned the defendant did have a stolen firearm inside that vehicle as well, and that firearm had been stolen from Daniel Saboda, S-B-O-D-A. As officers are trying to wake up the defendant, he is not initially responding. They're pounding on the windows. When the defendant does wake up, he attempts to put the car into drive, and he is essentially burning the rubber, just continuously trying to drive into the patrol car that is blocking him. When he realizes he can't get by, he then just starts backing up. He crashes into a parking garage where officers are behind him, and then after crashing, he attempts to drive forward at officers. And all of these officers are on that very small driveway, and there is essentially no way for the defendant to exit that area without injuring one of the officers that were on scene. So I'm going to pull up the body cam. I'm starting from 36 seconds. and 57 seconds. In this incident, one of the officers did have to discharge a firearm due to serious safety concerns. As stated, this was a very confined area where they were not able to move or get out of the way as the defendant continued to accelerate towards them. And as also stated, they did find a stolen firearm near him inside of that vehicle. Your Honor, two of those officers that were there today, Detective Howard as well as Officer Weber, are present in court today. I believe that Officer Weber's attorney, Bishen, would like to make a statement, if that's okay.
Just quickly,
Yes.
the felonious assault count with the 1-year firearm specification, and the because was there another incident in which he also took off and?
No, Your Honor.
Okay.
The indictment from this is from him attempting to flee the scene here.
Okay. And then the two felonious assault, the different counts 1 and counts 2, how are those different? It's just different victims?
Yes, Your Honor. It is because multiple officers were in the path of travel. There was also officers in the back of the home as well as officers in the front.
Okay. Go ahead. Mr. Beisheim.
Thank you, Your Honor. How are you this afternoon? Good. I was asked by Officer Webb to make a statement on his behalf, as well as the members of the Cleveland Police Department. As the court is aware of the circumstances of this incident, the suspect was located in this driveway, which is a very narrow area, and as the officers attempted to awake the suspect, he rammed the Cleveland police car multiple times, attempting to move it. He then attempted to escape to the rear. He took out the garage door, but he could not take out the garage. The only remaining place that he could escape was a small strip of grass and bushes located next to the police car. That is where approximately 6 officers were located, including Logan Webb, who was the closest to the suspect. Officers, I just want to point out for the court, are very hesitant. They are restrained in the use of force. No officer wants to have to pull out the gun, ever, and they certainly don't want to have to use it, especially with a young man here. But in the circumstances in which this car is coming at them, they faced imminent threat for deadly either death or serious injury, and Officer Webb had to fire to save the lives of a number of officers. Hopefully there'll come a day in this city when a Cleveland police officer's actions as a hero in using deadly force when there is an imminent threat of death or injury they are recognized as heroes. Unfortunately, we're in an environment today where that doesn't always happen. And oftentimes they are put on restricted duty for long periods of time, passed over for promotions, or face administrative charges. And I want to thank Officer Webb for his heroic actions today and all the members of the Cleveland Police Department, Detectives Norman and Detectives Howard in the back, for their selfless service, their dedication to this community, and for keeping us all safe. I have known Officer Webb for several years. He was involved and came within millimeters of one of the shots in the case that involved the tragic death of Officer Ritter. And these incidents of use of force have an impact on these officers, whether they are on the brunt of receiving deadly force aimed at them or whether they have to use deadly force. It does have an impact on these officers as victims. And I wanted the court and our community to be aware of that. Thank you.
I'm going to just go back and look to see this one more time. Yeah, absolutely. Your Honor, I just want to note kind of in the sentencing factors, just the serious mental injury that was caused to these individuals. Obviously, in both the first case as well as the second, in the first case, this juvenile is physically jumping out of the way to avoid getting hit by a car while walking on the sidewalk. And then is also having a firearm pointed at him. And then in the second case, these officers that are having to jump out of the way of a moving vehicle and being unsure kind of what the defendant is going to do next in this confined space. But also these mental aspects that both the officers as well as that juvenile had to do kind of deal with while this defendant was essentially terrorizing them. Your Honor, I also want to touch on the defendant's criminal history. In 2024, he had 4 different cases in the juvenile system. In 2025, he had 14 cases out of the juvenile the juvenile system. And in those kind of assessments that were made at juvenile as well as in the PSI, they found that he was in the 93rd percentile of juvenile offenders, and which is obviously considered a high offender level. They said that even once he was in the juvenile detention center, he showed a significant pattern of violence with both youth and staff. They also said that in these incidents, he was showing significant levels of unprovoked violence as well as possible premeditation, and these cases both involved the use of a firearm. In the juvenile system, he was given an opportunity for diversion, which he did complete. He also did have multiple intervention opportunities where the staff said he was not cooperative and was not really engaging in that process. Your Honor, this is a defendant that just repeatedly made choices that put other people's lives at risk. He was repeatedly putting people in harm, repeatedly putting people in danger. He was stealing vehicles, he was stealing firearms, and then he was willing to use those stolen vehicles and firearms to further future crimes. Your Honor, the state would request something above the minimum in this case. These actions are not the actions that deserve a minimum sentence. He has repeatedly shown a sense of callousness and has been given opportunities through the juvenile justice system that he has not taken. Thank you.
So, Your Honor, so initially, I mean, Jamez was 14 at the time of these offenses. He's 16 now. I do think he has a much better understanding, and he has matured quite a good deal, as evidenced by the improvements he's made at Indian River. He's very sorry to the police officers as well as the other victims. He understands that and is not casting aspersions on the officers. He's 14. He should not be in a car, period, let alone a stolen car, let alone not complying with the police orders. So there is nothing on his part to suggest that anyone was at fault here but himself. Accepts responsibility as demonstrated by the pleas he has entered into. There were no juvenile adjudications prior to these. The events that were there, although some were charged in 25, they all occur from maybe a 2-3 month period of time. Just sort of highlighting some of the things that were discussed in the sentencing memorandum. This was shortly after both his brother, who he's very close to, and his father were incarcerated, sentenced to prison. He had sort of lost the two of the primary male role models. His mother, who's here today, and sort of a number of people, his grandparents, uncles, his older brother. His mother was in nursing school as well as working, so despite the behavioral problems and things he's had since at a very young age, there was a lack of supervision at that time. His grandfather, who's a Vietnam veteran, who spent a lot of time with him, it also kind of had a period where he wasn't around as much. He had 2 friends, close friends at the time, that he went to their church with. They both moved. And at this time, He starts hanging out with different kids. His mom doesn't really even know who they are. One moved from New York. She believes they had a big influence upon him. In the robbery case, there were 2 other people present. I think peer influence had an effect. And when you look at, and I know I don't want to belabor it, but if you look at the sentencing guidelines in 2919 for juvenile offenders, all of the mitigating factors, including the chronological age of the offender at the time and the hallmark features of that, which include intellectual capacity and maturity, impetuosity, and failure to appreciate risk and consequences. I think they're all present. He's 14. He's had since age 5 a diagnosis of a developmental delay as well as other behavioral problems. So there is that history there. The family and home environment of the offender at the time of the offense, the offender's inability to control the offender's surroundings, a history of trauma regarding the offender, and the offender's school and special education history. There had been a substantial history of special education, probably needs beyond what he was treated for. Once he got to the juvenile detention center, he was treated for PTSD. He was prescribed medicine. He starts doing better and better. The circumstances of the offense, including the extent of the offender's participation in the conduct and the way familial and peer pressure may have impacted the event. And again, there was a new group of friends that sort of, here at age 14, had him along a path that he wasn't on previously. He did always have behavioral issues, a mental health contribution towards that. Now, he improved while at the detention center, but he has improved quite a bit while he's gotten to Indian River. I attached his last report card, which not only demonstrates straight A's for the 3rd quarter, he had improved steadily every quarter. He tells me he had mostly B's the 2nd quarter, but the teachers indicates that he participates actively in class, he uses class time wisely, he puts forth a good effort, and these are all things that I think he's improving based on the mental health treatment, the level of maturity. So he is very sorry for what's happened here. I know his family wishes in that sort of volatile couple-month period of time there was more oversight, and it just sort of shows how quickly things can go awry. So he apologizes to everyone. I know he's written a little statement that he read to me, at the jail Friday. I know he obviously, like any 16-year-old and probably one that's maybe less mature or has a lower IQ than others, he has a hard time expressing himself, but I think he does want to let the court know he wants to change from here forward. I think he's sincere. He's demonstrated it with his behavior and his schoolwork at Indian River. I know he'll have the support of all these people who I've spoken with, and I think they've all sort of related similar things that were occurring at the time that sort of just created this bad situation that really got out of control, and he knows that he did. So just ask Jamez to go ahead and...
Well, before he speaks, is there anybody, I do have the impact statements from the family members and letters of support. Was there anybody that was going to speak? I'd like them to speak before your client does.
So, Your Honor, I think, they all indicate that what they presented to you in the letters and what was submitted in the sentencing memorandum highlights sort of like the concerns they wanted to...
You're going to have to speak up for we hear you.
I want to say I'm sorry to the victim and these police officers.
You're going to have to speak up.
I want to say I'm sorry to the victim and the police officers, and I want to apologize for all my actions because I know they were not good, and that's all I gotta say.
This sentencing hearing centered on 2 violent incidents involving a teenager already deep inside the juvenile justice system. Prosecutors painted James Johnson as a repeat offender whose actions escalated from stolen vehicles to armed robbery and assaults on police officers. Surveillance and body camera footage became the foundation of the state's argument, showing both the robbery of another juvenile and the dangerous confrontation with officers in a narrow driveway. The prosecution emphasized the emotional trauma suffered by victims and officers, while also highlighting Johnson's lengthy juvenile history and repeated failed interventions. The defense focused heavily on his age, mental health struggles, unstable home environment, and the loss of key family figures during a critical period in his life. Attorneys argued that his recent progress in detention showed signs of maturity and rehabilitation. Throughout the hearing, the judge appeared focused on balancing accountability, public safety, and the reality that the defendant was only 14 years old when these crimes occurred. Thanks for watching.